Well, good afternoon, everyone, and thank you very much for joining us. I was just waiting 3 minutes to let everyone get into the room before we begin. And I think just in light of time and all the detailed information we're going to go through, we should begin. So good afternoon and welcome on behalf of the South African Chamber of Commerce to this webinar, where we will be talking about the essentials of estate planning with the South African expat view in Singapore. And I would like to give a special thanks to our sponsor, St. James's Place, as well as to our guest speaker, myself from St. James's Place, and Mr. Nanda from RHT Law Asia, whom I will introduce a little bit more. So just before we begin, a little bit of housekeeping for everyone. Please, if you can, just keep your cameras off, stay on mute. And if you have questions, please feel free to put them across to us at any stage. We have allocated a section near the end just for questions and answers. But if we see a question that's very relevant to the slide that we are on, we will try and answer it then and there. So without further ado, I'm going to move on. So in terms of the agenda and what we have in store for you as the audience here today, it's quite a jam-packed agenda, but in our preparation, we've tried to keep it very high level, and we would like to try and deliver this in a conversational manner. We'll try, but with the intricacies of law, we might get a bit carried away. So just in terms of what we're going to discuss, just a brief welcome and introduction as to who I am and who I work for, a brief introduction to our guest speaker, Mr. Nanda, and we will then get into RHT Law, and he will tell us a bit about his firm. Then from there, what does an estate plan consist of? Estate duty in Singapore and South Africa, the benefits of a will, what happens if you don't have a will, or I have a will in South Africa, what happens to my assets in Singapore? When you're making a will, what should you be considering? And as an expat here and you have children with you, have you nominated temporary guardians? Do I need a lasting power of attorney? Some of you might even ask, what is a lasting power of attorney? It's different to a normal power of attorney. And how does life insurance differ in Singapore to South Africa? And how does that form part of your estate planning piece? From there, we'll do the final Q&A and closing. So, but as I said, please pop us questions as we go, and we will then try and answer them on the spot if they're relevant to the slide. So diving straight into the introduction, my name is Michael, and to those of you who haven't met me yet, I'm an associate partner from St. James's Place. I'm also a board member of the South African Chamber of Commerce. I haven't been in Singapore very long. I've been here since COVID, essentially, and it's almost been 2 years, but it feels like one. I'm originally from the Eastern Cape, from East London. I went to university in South Africa for undergraduate and postgraduate. And then I've got UK qualified and Singapore qualified in my profession as a wealth manager. So in terms of who is St. James's Place and you know, the services we offer, we're a FTSE 100 company. We've got offices in Hong Kong, Singapore, China, the UK. We've got over 800,000 clients, and we manage in excess of $250 billion of their money. Two things that separate us from the rest, essentially, is the advice we give our clients is guaranteed, and we have a distinctive approach to investment management, and we're also heavily involved in charity. So that's enough from me and about St. James's Place. I'd like to now introduce our guest speaker today, Mr. Nanda Kumar Ranganathan, who is a partner of RHT Law. And Mr. Nanda is the Deputy Head of Litigation and Dispute Resolution for RHT. He's also one of the founding members and has been practicing law for 26 years, so almost as long as I've been alive. And Mr. Nanda handles a wide range of areas, and he's got a great amount of experience, but most notably for what we're going to be discussing today, Mr. Nanda is a Commissioner of Oaths. He's a notary public. He's worked and built a wills and probate practice that's very successful. So, Mr. Nanda, thank you very much for joining us today. Would you like to say anything?
Thank you very much for having me.
Sure.
And good morning, and I'd like to thank all the participants for taking the time to attend this webinar. Just to give you a quick introduction of our firm and myself, we are a full-service law firm in Singapore. We provide litigation, dispute resolution, and corporate commercial, real estate, intellectual property, and we also handle private wealth clients as well. In terms of what we actually do, I think it's going to be quite a lengthy discourse, so I'll spare you that. But essentially, I am the deputy head of litigation practice. I do a fair amount of litigation and arbitration work. And in addition to the practice where I am fairly involved in doing contentious estate matters as well, I also do have a strong probate and administration practice as well in relation to estates. So I'm a bit committed and dedicated in terms of wanting to help people, particularly in their time of need when an event happens. So that's where all this is coming from. So in many ways, I want to be able to help families through the difficult times that they go through, and hopefully improve their lives as they go along from there.
Thank you very much, Mr. Nanda. So without further ado, in terms of actual the content that we'll be talking about, and the introductions are now done, just diving into estate planning and what is estate planning, some of the tools that are available to you in order to set up your estate. And the word estate planning it's a little bit deceptive. I think the word succession planning is perhaps better. It's more so of what tools do you have available to ensure that not only the next generation, but perhaps your own parents are going to be looked after upon your passing, or even before your passing. And some of these things include people utilizing corporate structures such as companies, using trusts, family offices, and then also having the correct documentation in terms of wills and guardianship, lasting powers of attorneys in place. These are the elements and the tools of successful estate planning or succession planning. But in the nitty-gritty, in terms of the formalities, the paperwork, what does an estate plan consist of? Having a will, and as an expat living in Singapore, nominating temporary guardians to take care of your children in the country that you live in residence, till such a time that a permanent resident, the permanent guardians can come across and take care of your children. And then a lasting power of attorney to basically ensure, if you are incapacitated, your affairs are still taken care of in a manner that you would want it to be, but also by people that you trust it to be. So in terms of estate planning and estate duty for South Africa, and as South Africans living abroad, it's not your physical presence and where you pass away. It doesn't actually matter. What matters is if you deem to be an ordinary resident in South Africa at the time of your passing, you will be taxed on your worldwide assets within your estate. Now, in terms of life insurance and pension funds, if you have pension funds or life insurance policies within your estate, those can be left outside of your estate for the calculation, essentially. But then a abatement of 3.5 million rand, which is just less than, let's say, 320,000 Singaporean dollars, is available to every South African before they will be taxed. Anything in excess of that will be taxed at a flat rate of 20%. If you are married and you have a spouse, that can be multiplied to 7 million. So essentially up to 7 million Rand would be without tax. And as I said, estate duty is payable at the first level at 20%. It gets quite a bit more expensive once you exceed about 3 million Sing dollars. So taking care of your planning and doing your calculations to ensure that you pay as little tax as possible, or that your beneficiaries pay as little tax as possible, is quite important in regards to this, no matter where you are in the world, if you consider to be ordinarily resident within South African tax law. In terms of, so that's South Africa. Now, in terms of Singapore, taxation in Singapore, there is no estate duty in Singapore at all. So if you could be, this could be your sole tax residence, it's a great place in order to set up your affairs. And should you pass away, there would not be estate duty payable. There's no forced heirship regime in Singapore except for the estates of Muslim people domiciled in Singapore, as set out by the administration of the Muslim Law Act. So in a nutshell, that's the state duties that you could be on the hook for as a South African living in Singapore. Now, over to you, Mr. Nanda. If you could share with us, in your experience, what are the benefits of a will?
The main benefits of a will, and we've actually set that out in the slide itself, but you can see that the main benefit is that you are able to decide on who the beneficiaries are of your estate and who gets what. And I think the distribution is something that you are able to apportion based on what you want to achieve in terms of your overall strategy for giving out the payments that are there from your estate to your beneficiaries. If you look at it from the perspective of a will, you actually have the ability to also make provision in your will for gifts that you want to make, for example, for charity, which generally, if you look at it from an intestate perspective, that means when you don't have a will, the money that is going to be in your estate will go strictly in accordance with the law. Now, the other benefit of having a will is that you are under the will required to appoint an executor. An executor is the person who is going to be collecting your assets and distributing them at the time when he is able to do so after he obtains the order of court to enable him to do so. Now, the point is this executor that who you appoint can be chosen by you, and that person will be the person who's going to be able to go ahead and do what he needs to do. In an intestate succession sort of scenario, that means where you do not have a will and you are therefore going to have to administer the estate in accordance with the law, the person who's going to be appointed by the court may not necessarily be the executor that you want. That person is basically could be a person who is applying to the court, and that person could be your next of kin, could be your spouse, or could be your creditor, because the law allows your creditor to also make such an application in the event no one else is making that application. So it takes control away from you in your ability to actually control who is going to be the person who's going to administer your estate. And I think that's what the crux is about. It's about whether you are going to have the power to determine who is going to administer your estate. And the second thing is that the assets in Singapore will be distributed in accordance with your wishes if you have a will, which is not something that you have control over if you don't have a will, right? So it goes in accordance with the law. So that is exactly the essence of having a will. It is you get to decide how, when, and to whom your assets are distributed. Now, if you go on to the next slide, which relates to what is intestate succession.
So before we go there, I think, Mr. Nanda, it's important to note that if I had the choice of nominating someone by will to look after my affairs or my creditor,
Yes.
I would far prefer someone who I don't owe money to take in control of all my affairs and potentially taken away from my family. So good note on that. But the questions are, also about, who should have a will? And, people who, if you answer yes to any one of these countries, basically you should have a will in place. Do you have multiple assets in multiple jurisdictions? Yes, you should have a will. Do you own a business? You should have a will. So essentially, these are just little things that questions we would ask clients when they're asking about, the suitability of having a will, if it's necessary. And generally speaking, the answer to yes to any of these results in you most likely should have a will in place. So in terms of intestate succession and how it works in Singapore, Mr. Nanda.
Yeah, so the reason we actually have the Intestate Succession Act is that it acts actually as a safety net. And it's a safety net because in the event you don't have a will, there has to be some form of distribution of your assets. And this Intestate Succession Act actually determines how that distribution is going to take place. In many ways, if you know what's going to happen in the event you don't have a will, it sort of allows you to better plan and have a scenario where you're going to be able to say, okay, so it's better for me to have a will, right? Because you may not exactly want your assets to go in accordance with the act. But just to give you a flavor of what this act is about, it actually is an act which it doesn't govern Muslim estates. It actually does govern the rest of the estates that are there. And the rules of distribution are set out in under Section 7 of the Intestate Succession Act. It says essentially this, and there's 4 rules there, but there's a lot more. The rules actually go down all the way until the point of saying at the end of the day, if there is no one else to give the money to, it will go to the state. But at the beginning, the act actually says that if you have a spouse only and you don't have any parents and you don't have any children, then your spouse becomes entitled to the entire estate. The second rule is on the basis of saying if you have a spouse and you have children, then half goes to the spouse and the remaining half goes to the children in equal shares if there are more than one. The third rule is that if you have children only and there's no spouse, then it goes to the children in equal shares. And if you have a scenario where there are no children, all right, and you have only spouse and parents, then the parents will be entitled to half and your spouse becomes entitled to the other half. Okay, so you actually have a scenario where it goes up if you can't go down. That's how it's structured, all right? And then it goes laterally. So if you have no spouse and you have no descendants at all, then it goes to your parents. And if you have no spouse, you have no descendants and no parents, then it'll go to your brothers and sisters. So it's sort of like it tries to go around. But at the end of the day, it will end up going to the government if there is no other beneficiary that can be found. Now, remember, when you have a will, you don't have that problem. You can actually leave this to a friend. You can leave it to your partner who is not legally married to you. You can do that, but you can't do that in intestate succession. Now, there's one other quirk, and that is in relation to immovable property. If you have property in Singapore, then that actually goes in accordance with what is known as lex situs, basically in accordance with the law of the land. And if you have left the property in accordance with your wishes in the will, and the person is not eligible to hold that property, then you may have to make certain decisions in respect of that. So, potentially your executor may sell the property and may distribute it. So those are the rules that are there, and these are specific to property. But usually, if you are owning the property and you are not a Singapore citizen or resident, then if you are giving away the property, it must be eligible to be given to other people. So it's not really a problem, but it's just something that you have to be aware of if you're buying property in a certain jurisdiction.
Understood. Mr. Nanda, so essentially having the will allows you to execute your wishes, opposed to letting the state execute it as they deem fit. Some questions.
No, not really.
Yes.
Sorry, Michael. I think that's not really the case. It's not how the state is going to distribute it. It's just that the administrator of the estate will have to distribute it in accordance with what the state stipulates under legislation. So it's all in accordance with the law. And usually the administrator will have no choice but to go ahead and distribute it in accordance with the law. Whereas when there's a will, the executor can do it in accordance with the will and does not have to follow the Intestate Succession Act. I think that's the point there.
Agreed. Just briefly, we've had a few questions just simply about how does this apply to Muslim estates? Does the Intestate Succession Act also apply to Muslim estates in Singapore, especially if they are expats per se?
The Muslim estates are actually regulated by what is known as the Administration of Muslim Law Act, and the regime is slightly different. But I think it goes in accordance with Sharia law. So there are very specific amounts that can be given away by will, but there are some sums that cannot be given away by that. It's a bit more. The rules are a bit more complex, but it's something that and I don't think it's something we want to go through right here. But if you have queries on that front, please send them to us, and we are happy to answer those questions.
Very good. So just moving on to the next slide then. Another question that I get a lot is, I have assets all over the world. Where should I have my will? Should I have one will that dictates my entire estate? Should I have one will for each area that I hold assets? What are the benefits of doing so? And generally speaking, I think Mr. Nanda would agree, is having a will in each jurisdiction would speed up the process of probates massively, because if you have only one will for your entire estate, it has to travel around the world and go through probate in each country where your assets are held. So having a will in multiple jurisdictions, or every jurisdiction where there are assets, could be to your benefit. And for example, if you are a South African and you have a South African will that dictates most of your estate, and you still have assets either in Singapore or further abroad, it would benefit you to have a will wherever you hold assets, simply because if you do not, as South Africa is part of the Commonwealth, if you have a will that governs all of your assets across multiple jurisdictions, it needs to go through probate in South Africa. Then from there, it would need to go through probate in the next jurisdiction, say in Singapore, through the process of resealing of foreign grants of probate and letters of administration. So we'll go into what happens now if you only have the South African will for all of your assets. And when we go through this, you'll get a feeling for just how complex it could be and how long it could take. So over to you, Mr. Nanda, the first kind of step of the process.
Yeah, so if you look at it from the perspective of how you are going to be able to obtain the grant of probate. A grant of probate, okay, so you have the will that has been signed, and the will then proceeds to reading at the time after your passing. And at that point in time, the executor will need to apply to court for a grant of probate. Now, this grant of probate is essentially, if I was going to put it in any other way, it's an order of court. Whether you call it letters of administration, you call it a resealing of the grant of probate, they are all orders of court. And essentially what's happening is that your executor will be able to take the original will and he will be able to file it in court. Of course, there's a process he needs to go through, but he will be able to file it in court and obtain what is known as a grant of probate, which then confers upon him the authority to collect all your assets and distribute them in accordance with your will. So that grant of probate is one way of making that application. He's the one making the application. Letters of administration, again, someone else is going to be making that application to the court, but it's a bit more complex because there are people who are going to be entitled to apply for this grant together with you under the law, and you would have to determine who is going to make that application. And that process also will be taking, it's time consuming, right? The third way of doing this is if you already have a will and that will is made in South Africa, for example, you may actually have a scenario where this will, because it is from a Commonwealth country, Commonwealth jurisdiction, you are able to do a resealing in Singapore. That means you can, if you have obtained a grant of probate in South Africa, you will be able to bring it into Singapore and apply to the Singapore court for a resealing of that grant. So that's possible for you to do. Now, the difficulty that you're going to have is that when you have wills, one will that covers your entire assets in, say, 3 different jurisdictions. Okay, so you have 3 jurisdictions where you have assets, but your one will covers, and a lot of wills are drafted that way. It says it covers all my assets whatsoever and wheresoever situated. It covers your entire assets. In such event, what's going to happen is you're going to have to file that in South Africa, obtain a grant of probate there in South Africa. And then the courts like to keep this document. So the courts will be saying, I'm going to keep the original of this document. What are you going to do? But you will need that original of the document in Singapore for you to actually file it in court. So in Singapore courts, they do allow, they get the courts in overseas jurisdictions to actually certify it as a true copy, bring that document into Singapore and use that for the purpose of applying for the grant. But that takes time, right? Because not all courts in different jurisdictions operate at optimum levels very quickly. It may take a few months before you're going to be able to get the appropriate documentation over to Singapore in order for you to do that. But if you have a will that you made in South Africa for the assets in South Africa, and you have a will in Singapore for the assets in Singapore, then you can, there are 2 independent documents. You can file in South Africa, you can file in Singapore. And there is no lag of time because essentially you are making the applications concurrently. And when you're doing that concurrently, it moves a lot faster. On average, you should be able to apply for and obtain a grant of probate in Singapore, something between 6 months to a year. And that's the timing that it takes. Now, just imagine if you have to wait for 6 months for that grant to be obtained in South Africa, in order for you to take that document and bring it to Singapore and then reseal it and go through the process again. It's going to take you a longer time. And at the end of the day, if you want your beneficiaries to be able to avail themselves to your assets quickly, then the right way to do that will be for you to have differing wills in different jurisdictions. Of course, that doesn't mean you have to do a will for every single jurisdiction in which you actually have money. But I think you need to identify where the majority of your assets are. And insofar as they are in Singapore, you will need to try to see how you're going to be able to protect them by doing the wills in Singapore and maybe doing a will for South Africa. And if you have some other jurisdiction, then you'll have to think, because not all wills in different jurisdictions are resealable. You can't reseal a will that's been done in other countries that are not Commonwealth countries in Singapore. So you're not going to be able to have that benefit. So that is again something that you need to think about. The other aspect of it is that essentially it does take longer, and you actually have, because of the nature of the assets that you have in different jurisdictions, you actually have to consolidate all of them at the same time. Whereas if you can do it independently, that allows you a greater deal of flexibility. So I think that's important for you to look at.
I think also when you are an expat and you are living abroad, and let's say that your family is here with you, and should something happen to, you know, the breadwinner or both of the husband and wife, and the dependents have to go back to the home country, and they're dependent on a will that's in that home country to dictate the money that sits in Singapore they need for survival. Waiting 6 months or more, perhaps 12 to 18 months, is not really, it's not really feasible. And also in this modern day and age where everything, we've got, you know, digital trading accounts and digital bank accounts and digital everything, even just having a simple list of your login details and passwords and having that sat with whoever you trust. For example, my fiance's got all of my access accounts for everything that I have. Just small things like that that people can put in place should something happen. So if something happens to me, she can still access my accounts online and do whatever we need to survive. That's just an additional piece of consideration. So what makes a will valid? This is important because the last thing that you want is to obviously take out a will that you think is going to help you, and then all of a sudden it's not going to be, the courts will not recognize it.
The requirements for making a will valid are actually there for a reason. It is effectively to ensure that the will is not open for contest, right? When you have a scenario where someone is unhappy with what you say in the will, and usually when a person is applying to set aside a will, it is for not meeting technical requirements. So it's important for you to ensure that the technical requirements are actually taken care of. And the requirements are not complex, they're actually fairly simple, but you do need to ensure that religiously these are observed. For example, the will must be in writing, that the testator must be a major, that is over 21 years and above, right? Third one was testator must have mental capacity. Now, this mental capacity thing is not something that should be taken lightly. Many years ago, I actually did have a client who came to me. She was suffering from cancer, and she said to me, I need a will done because I'm going through cancer and I do not know how long I'm going to be around. So I did the will for her. And she never executed it because she needed she was in treatment. And after a while, she said, I'm in remission now, so I'm going to go away for a holiday. I'm going to Bali for a holiday, and I'll come back and I'll sign the will when I can. A few months passed by, and then I received a call from the husband to say, she's in hospital right now. Can you come and have the will signed? I did rush down. I brought the will with me because I knew there were very specific requests that she had made in the will, and she needed it given to certain people. So I went down, but by the time I got there, she was not conscious anymore. She did not have the capacity to sign the will. It was quite sad because in those circumstances, subsequently she passed away, and I administered the estate, right? So I helped the family with the estate, but I actually knew that her wishes were other than what the law actually prescribed. And that I felt was quite sad. So mental capacity, I think, is one of those factors which someone independent is going to have to be able to say with some degree of certainty in order for you to be able to sign the will with the proper requirements. Then, of course, it has to be signed in the presence of two witnesses who are there at the same time and who witness each other signing it. And one of the requirements is that whoever is the beneficiary should not be a witness. naturally for conflict of interest purposes. And I think that's important. Technically speaking, you can, if you do it right, you can do the will yourself. But I would recommend that you engage a third party or a lawyer to actually draft it for you and take you through it, because this element of independence is quite important when it comes to ensuring the integrity of the will.
Sorry, I was on mute. I think just running through this and the simplicities, I mean, it does sound rather simple, but if any one of these elements are not included in a will, then it could potentially not be recognized at all. And that would stop a will from being properly executed. So, Mr. Nanda, when is a will properly executed?
So actually the will is properly executed if it is in accordance with the law of the land in which the will is executed. So if you look at the territory, for example, and Singapore requires the will to be executed in a certain manner, and it is signed in Singapore, then it would be valid before the two witnesses. But there may be countries where you do not need the same requirements in order for you to execute a will. And if it is legal in that country to execute it in a certain manner, and it is done in that manner, then it is still valid. But the difficulty that we have is that usually that will need to be proven. So in order for you not to go through that difficulty, sometimes it's just best to sign the will in Singapore. That way you don't have to prove all these in court when you actually get into that point where you need to make an application for the grant of probate.
I think just going on to the next one, this was something that Mr. Nanda actually educated me on when we were preparing for this, is an affidavit of foreign law, and when is that required, and who you can actually get it from.
The affidavit of foreign law is actually based on domicile. So in many ways, when you're applying for the grant of probate, you will need an affidavit of foreign law in accordance if that person dies who is not domiciled in Singapore. If you die domiciled in Singapore, no issue. But if you die domiciled elsewhere, then you will need to apply for an affidavit of foreign law. And when you, this affidavit of foreign law is actually an affidavit that is given by a lawyer in a foreign jurisdiction, who is going to say, yes, in accordance with that will, the executor should be this person, and there's no issue as far as our laws are concerned on that front. And most laws don't have a problem with that. So you will probably have an affidavit of foreign law, which a lawyer there will need to do that. And when you are having separate wills in separate jurisdictions, and your domicile differs from the jurisdiction in which you have actually executed the will for probate, then I think most countries may require an affidavit of foreign law to be submitted to the court as well. And this is usually given by a lawyer in your own jurisdiction. Could be a lawyer who's doing the probate in your own jurisdiction, that's fine. But it is something that needs to be done and provided to the court. And of course, the affidavit, where you have a scenario where the affidavit of foreign law is given, where there is no will, it has to be a bit more extensive. So that's one of the benefits of having a will in a different jurisdiction. If you don't have a will and you're applying for grant in a country other than the country in which your will applies, then you will need to, the lawyer will need to state whether you actually have the capacity to apply, who is supposed to be entitled to the estate, if it goes into the intestate regime. So if the bottom line is still this, if you have a will, it becomes fairly straightforward. If you don't have one, it becomes a bit more complex. Like for example, if you don't have one and in Singapore, and your will does not apply in Singapore, and you've made one for another jurisdiction, if you apply under the law, Intestate Succession Act, to be appointed the administrator, one of the hoops you need to jump through is having the dispensation of sureties. When I say dispensation of sureties, what I mean is it's like being a guarantor. If you are the person who is going to be the person who is going to be administering the estate, the court may ask you to be a guarantor for that value of the estate. And most of the time, most people are not able to find a surety. That means to say that I have a person who's going to be able to ensure that I distribute the assets in accordance with the law. So I am going to apply to court to dispense with the need to provide a surety. And if you are able to apply to court, the court will sometimes dispense with the need, and that's okay. But if you have to jump some hoops in order for you to actually get to that point. You have to ask a few people whether they're going to be able to be your surety, and it becomes complicated and complex because of the nature of that application that is going to be made to the court. Now, it's not impossible, it can be done, and I've done it several times before. But my point is, it does delay your ability to get to the grant. So if you have a will, it makes it a lot more straightforward on that front.
And just touching on Mr. Nanda said domicile. For South African tax law, domicile is ordinarily resident. And if you also hold a UK passport, you should really look into if you fall under the UK domicile as well, because they're quite extensive in their inheritance tax as well. And many South Africans do also have British passports, so I just thought I'd raise that. So moving on to our next bit, and thank you everyone for the questions that we are getting through. I will field them just a little bit further on. Now, the considerations when making a will, and I said this to Mr. Nanda in our preparation as well, it's very similar to when I'm working with my clients. You know, life events are very important. So should you even change your address, you should definitely know your investment manager or your lawyer or even your doctor. They should know where you're staying. Any life event like that, or a divorce, or a passing away of a spouse, or anything like that, you should definitely let your lawyer know, so they can, one, update your affairs, and two, also your location of your assets. As Mr. Nanda and I have now touched on, it's quite complex if you have assets in multiple jurisdictions, with the resealing process, with if you don't have the correct will in place, and then you have to go through the foreign affidavit. It can all take a lot of time. So these are just two of the events that are in consideration of making a will. Mr. Nanda,
Yes,
just
absolutely.
Would you agree?
Absolutely. I think the fact is that we all go through life events, and you should basically review your will periodically, depending on which stage of life you're on. So, you know, the reality is that your priorities change over time, and so do your family metrics. So you will probably want to see how you're going to be able to structure your will, or do changes to it. For example, there are things at law. Marriage, for example, will revoke your will. And that's under Section 13 of the Wills Act. And you actually have a scenario where, if you were not aware of it, you may actually die intestate, even though you actually have a will, right? So think about it from that perspective. But on the other hand, having a child or getting a divorce will not revoke your will. So it is quite possible that you may have named your ex-spouse as your beneficiary under your will. And if you don't update your will, then your will continues to stand. And you actually have a scenario where you're going to be able to pass on your estate to your ex-spouse simply because your ex-spouse is named as the beneficiary under the will. So these are things that you need to think about. And I think our needs will change. The factual metrics of how we sort of exist also changes. And I think it's important for us to be able to reevaluate every few years. It's not something that you need to do every week or every month. It's not something that is going to be so significant. But when there are life-changing events, when beneficiaries that you have named in your will are no longer around, you have to make decisions. You have to decide how this now is going to go down to the next generation, or who is this going to be the recipient of that portion. Is it still going to be the person who you named there, or the estate of that person, right? So these are things that you need to think about. And of course, the other aspect of it is you have to look at your location of your assets. If your assets are specifically located, of course, nowadays, you have scenarios like cryptocurrency that has come in. And where is it located, right? Yeah, it's going to be a bit difficult for you to actually figure that out sometimes, because it could be, your wallet could be in any jurisdiction that you sort of set it up in. And these are things that you are not going to be able to so easily pin it down. And of course, if you do have cryptocurrencies, my advice would be for you to actually allow or at least have a place where you kept details, appropriate details, so that your executor is going to be able to at least reach for those assets. And I think that's something that you need to do a bit of planning on, because that's part of the planning process that you need to get into. But otherwise, generally ask yourself where your majority of your assets are, whether they are in bank accounts, whether they are in properties that are in different jurisdictions. And if these properties are in a certain jurisdiction, then that's probably where it's best for you to have a will. So look at it from that perspective. And I think that's probably a good way to start to isolate which are the wills that you need to do in different jurisdictions.
And that goes to what I was saying earlier about having your online details for your trading account, for your crypto account, for your bank account. Have it somewhere safe. Give it to the person you trust. It's a very important part. So the last thing, one of the last things I just wanted to touch on as well today was the nomination of guardians. So if you have a will drawn, let's say you had your will drawn in South Africa and that's where your family is and you have children, and let's say something happens to you, generally speaking, in your will, you would have nominated someone in your family who's in South Africa to take care of your children. For some of my clients, I've seen as their parents. For some of my clients, I've seen as their brothers or sisters. Now, in a situation where we're in, like now, it's unparalleled times, right? With COVID, borders are closed. If you cannot get your permanent guardian to come across and collect your children from Singapore, should something happen to you because of the border closure, what happens to your kids in the meantime until such a time that A, they can be flown to the permanent guardian, or B, the permanent guardian can fly here to collect them? And this is where the discussion of a temporary nomination of guardians is very important. This will be talking about who do you have within Singapore that you would trust to take care of your children should something happen to you. Let's say, mom and dad go out for dinner and they don't come back, sort of scenario. What actually happens is children will become a ward of state in Singapore. And yes, I mean, Singapore is a lovely country. It's a first world country. And in comparison to South Africa, that would probably be I would rather have my kids as a ward of state here than in South Africa. But at the end of the day, the child would have gone through extreme trauma, lost potentially both parents, and now they're stuck in government care, unsure of what's happening and how they can get to anyone they know or receive care. Now, having a nomination of a temporary guardian who is then eligible to take care of your children in that scenario until such time that the permanent guardian can take hold is extremely valuable, and just gives you that little bit of peace of mind. So, Mr. Nanda, in terms of the power to appoint these guardians, have you gone through an experience where you've drafted a will with someone and added guardians or potentially also temporary guardians?
Yes. So you would have a scenario where guardians are appointed under the will. Parents actually have to think this through. And you have a scenario where one parent may like one guardian, the other parent may think this person is not really suitable. So sometimes when you do appoint guardians, it's best for you to actually have a discussion with your spouse on who you think is appropriate, so that is more or less agreed. And the reason for that is because if one spouse does pass away and has nominated a guardian, you'd have a scenario where that guardian will then need to work with the other spouse. And if there is really a lot of disagreement that's going to come from working together with the other spouse, then the guardian may actually have to apply to court in circumstances where there's simply no common ground that can be achieved. It doesn't happen very often, but I have seen scenarios where spouses have nominated guardians probably without thinking about it very much, because they think it's an unlikely event, but they have nominated people who, as guardians, who at the end of the day may not work very well with the other spouse. So it's best to have that discussion, find that person who's going to be trustworthy for your purposes, and then appoint that person as your guardian.
Very, very well noted. And now, one of the most important things is the lasting power of attorney as part of your succession planning set or tool set. Some people might have heard of what's called an enduring power of attorney. In some jurisdictions, a power of attorney of this nature is called enduring. So, Mr. Nanda, what is an LPA and what are the benefits of it?
So, an LPA is basically, as you point out, a lasting power of attorney, where you appoint one or more persons as your donee. In other words, your attorney in the sense to make decisions on your behalf when you no longer have mental capacity. And these decisions could relate to your personal welfare or your property and affairs. So it could be any one of these things. Now, a lasting power of attorney is only activated when you lose mental capacity. Otherwise, it has very limited value. In fact, there's no value. It only has value when you actually lose mental capacity. Now, actually, the question is, why is it that you need a lasting power of attorney? You see, a will is actually about caring for your beneficiaries. A lasting power of attorney is in many ways about self-care. It's about caring for yourself. And the reason you need to do that is because none of us knows when we are going to lose mental capacity. For example, I think the most obvious example that you can have in terms of losing mental capacity is if you suffer from Alzheimer's or you have dementia, right? But what about a scenario where you have been in an accident and you've been involved in an accident where you are not going to be able to make decisions? Like many years ago, even before this mental capacity, this act came along in relation to appointing the lasting power of attorney. I had a case where this owner of a business was riding his bike in the East Coast Park in Singapore, and he was subsequently discovered lying next to his bike. He'd obviously suffered an accident and some brain injury as a result of that. So he was brought to the hospital and he went into a coma, and he was in a coma for close to 3 years. At that point in time, there was no lasting power of attorney. That regime was not there. And we had to apply to court for his family to actually access his funds, because he was the sole owner of his business. He was the sole signatory to the bank accounts of his business. He was also the sole signatory to the bank accounts of his home. And because he was also the person who had taken out the mortgage on his premises, his mortgage payments needed to be paid. And of course, you had all the other issues that were coming up. His employees needed to be paid from the bank accounts. And because he was the sole signatory, the company could not release monies for salaries for his employees. So this lasting power of attorney actually was intended to solve these problems because it kicks in fairly immediately when you lose capacity. In that particular case, we had to apply to court. It took us something like 6 months before we actually had the orders to enable the family to continue to function. Yes, good thing is they had very strong partners who were able to say, yes, we will still continue to work with you, notwithstanding that these payments were not being made, because we know the assurances that we will get paid eventually. But you didn't have to go through that, because if there was this regime of lasting power of attorney, you would be able to access those funds immediately. So it's about self-care and allowing someone else to make these decisions on your behalf. And that's the reason why you need to have a lasting power of attorney. And how is it that you are going to be able to do this? You're going to be able to do this by executing this document in accordance with what is required by law and lodging it with the Office of Public Guardian in Singapore. So is it something that you can do without much of a hassle? The answer is yes. It takes a little bit of time, but it saves you a lot, saves you and your caregivers a lot of time and energy in the event that you lose mental capacity.
Ms. Nanda, just in light of time, we've just touched 1 o'clock, and to our participants who are still with us, I would like to just field some of the questions that we have received. And once we've gone through the questions, if you're still able to stay on just for another 5 minutes or so, we will then be able just to cover off the last bits of lasting power of attorney and the differences in insurance policies here. But we received a question here on this slide, just a lasting power of attorney and a power of attorney, are they different?
Yes, a lasting power of attorney is actually intended for your trusted person whom you are going to be nominating, and call them the donee, to make decisions on your behalf, right, for your personal welfare and your property. So that is a power that is given to them to continue to exercise their rights over yourself. They can decide what sort of appropriate treatment you're going to be given. They can decide how much money is going to be taken from your bank account and utilized towards your expenses. They can make those decisions for you. Whereas a normal power of attorney, which is something that you give, would only be intended for a very short period of time, and it is intended for a specific purpose. So for example, you may actually have a power of attorney for a person who is going to be selling your property in Singapore. And if you have that person selling your property and allowing that person to then receive the payment or the proceeds from the property so that they can be sent to you because you're not here. So you're giving them the power of attorney to actually sign certain documents for a specific purpose. And that's the difference. A lasting power of attorney actually lasts for so long as your disability is there. If you are not able to have capacity, then that power of attorney continues to remain. And in many ways, it is seen to be the one thing that is going to be there until such time, if you don't recover capacity, until such time you pass away. And that's when your will kick in. So you are actually protecting yourself in many ways, looking after yourself until the point of time when you do pass away.
I think it's very clear. They're completely different. One is very specific for one transaction or one set of assets, whereas lasting is for the entirety of decision making on your behalf regarding assets, welfare, or etc. Now, another interesting question that we've got here is one regarding having wills in multiple jurisdictions. They have drafted a will in one jurisdiction, and within this jurisdiction, there's been put a revoke clause. And essentially, when I asked for a little bit further information, they said when we drafted our will with our lawyer in South Africa, there's a revoke clause that revokes all other wills and claims the current one as the only one. Now, if there are multiple wills for multiple countries, should that be removed?
Yes, that needs to be tweaked because if you actually go down the path of putting one will in one jurisdiction and the other one revokes all the other wills, that's not going to work. So it's important for you to be able to you are going to be revoking your previous wills that you have entered into. That's fine, but you need to limit that to say that it is limited to the previous wills that you've done in this jurisdiction, right? And then you for the other wills that you're doing in other jurisdictions, you don't have such a clause, right? So you basically you will need to tweak the clause so that they all can coexist. All your wills can coexist together. And then when you're going to have to revoke any specific will, after that you have to put in a revocation clause that says, I'm revoking that specific will, so that you don't have a scenario where you create confusion. Because once you create confusion, then that is exactly what your will is supposed to do. Take away confusion. It goes in the opposite direction, which is not good.
Agreed. And the last question that we've received here is, if we made a will some time ago, and the co-executors and trustees' names, should they be removed from the will, as at the time the children were below 21 years of age when it issued?
Yes, so that's correct. So if you have your trustees who are named to administer the your estate, or and you actually have a scenario where your children are over 21, then your children can now become direct recipients. So you do not have to have the trustee look after the estate for your children. Normally there'll be a clause in your will that says that your trustee is then supposed to look after these assets until they reach the age of 21. But if they're already 21, then there is no requirement for that. So yes, you will need to change your will and update your will. It's probably best for you to do that anyway.
That, I think we've answered the questions, all of them that we've received so far. So just in light of time, everyone, we've touched on what is a lasting power of attorney. If you would like to learn more about a lasting power of attorney, please pop us a word in the chat box, and then I can get the additional information to you. I will be following up after the call to make contact and ask for feedback about the event, and also to just ask if there's a particular area that you would like more information on. At that point, I can provide you with the slides. This is also all being recorded, so we can provide it to you to watch in your own time. And should you need further guidance or information from Mr. Nanda or myself in terms of the South African affairs and planning what you have there and here, we would be very happy to field your questions and to provide value where we can. The whole purpose of today was to try and bring some value to the community that I felt was lacking. So just given that it's now hit 1:06, if it's okay with you, Mr. Nanda, I think we should end here.
Yes, thank you very much for having me at this webinar, and thank you very much and to the audience, I would and all the participants, thank you for listening to what we are putting across, and I do hope that it has added value to what you are actually looking at. But if you do have specific questions, then feel free to approach Michael anytime, or myself, and we are happy to answer your questions.
Again, Mr. Nanda, your time is extremely valuable. I know you paid per hour, so thank you very much for joining us. And to the audience, please follow us on all of our social medias. If you search for us on Facebook at South African Chamber of Commerce Singapore, on LinkedIn, South African Chamber of Commerce Singapore, and also on YouTube, you would see all of our previous events, as well as all of our future events on those platforms. So we look forward to having you at all future events. And again, from the Chamber, from myself, from Mr. Nanda, thank you very much for joining us today.
Thank you.